Hi, my name's Gilbert Ambler. I'm a firearms attorney at Ambler Law Offices, and earlier this morning, we received a decision, and when I say we, I mean the Second Amendment community, received a decision from the United States Supreme Court that is a groundbreaking Second Amendment decision, will change the landscape of how the Second Amendment is viewed in this country, and is something that we have been waiting for a very long time. This decision in New York State, Rifle Pistol Associations versus Bruin, addresses the question of carrying a firearm for self-defense outside the home. And believe it or not, in the United States of America, in many states, there was not a clearly recognized constitutional right over the past several hundred years, or at least over the past 100 years, as has been limited by states, to carry a firearm for personal protection outside the home. This decision changes that, but that's not the main thing. That's not really the important thing this decision does. Because the main and important thing that this decision does is it gives us a constitutional test on how firearms challenges are to be viewed. To non-lawyers, this may sound unimportant, but it is critical. Because having a test in place is what tells courts how to view these firearms challenges. And what has been happening in much of the country is that courts have been treating the Second Amendment as a second-class right, erroneously, wrongly, and unfairly treating it as a second-class right, but it has nonetheless been affecting these firearms cases. And that activity will have to stop given the new decision from the Supreme Court. Now, I'm not saying that these lower courts will not seek to minimize the right at every chance they get. But this decision from the Supreme Court is a pronouncement from the United States Supreme Court that this activity of giving it a lower status, of giving it a constitutional standard closer to intermediate scrutiny, which is a different constitutional test and a much weaker test, is going to have to stop. Second Amendment rights will now be treated as rights equal to other rights, or at least they are going to be, the Supreme Court is telling them that they should treat this as a right equal to other rights. So what does this mean to us? It means when we bring firearms challenges, we now have a roadmap, we've got a path, we've got a test that the court can and should turn to in order to fairly interpret this right. No longer should we see courts turning to what the government wants to see happen. Because after all, the government has consistently gotten this wrong. The government has constantly wanted to minimize firearms rights for law-abiding civilians. We no longer defer to what the government wants. Now we use a constitutional test known as text, history, and tradition, a test that is going to be focused on what the founders expected when they passed the Second Amendment. And keep in mind, the founders' expectations at the time of passing the Second Amendment had just shrugged off the tyranny of Great Britain. They had just fought for their freedom, and they certainly believed in the right to carry firearms for their own personal protection against other enemies, either foreign or domestic. This is an exciting day for the Second Amendment. It's an exciting day for these challenges, and it's going to open up the floodgates of Second Amendment litigation. Here in the Fourth Circuit, where Virginia sits, for example, we now may be able to bring as-applied constitutional challenges for people that have lost gun rights due to something as inconsequential as a shove 20 years ago that was labeled a misdemeanor crime of domestic violence. I understand why the law seeks to prevent those convicted of misdemeanor crimes of domestic violence from possessing firearms, but the way this law has been applied has been far-reaching and has had consequences for people who never imagined that they might permanently lose their right to keep and bear arms. Challenges for these individuals to these prohibitions have now been opened by the Supreme Court. As you can tell, I'm very excited today. It's going to change a lot of the Second Amendment litigation. As recently as a couple of weeks ago, I argued for a temporary injunction against the city of Winchester that had imposed restrictions on firearms. And during that argument, I advocated for a constitutional test that is almost directly aligned with what the Supreme Court just gave us. So lots of very exciting stuff going on right now, and we're looking forwards to how this will change future litigation. If you have questions on this subject, you can reach my office at 540 540-550-4236. Again, that's Ambler Law Offices at 540-550-4236.